I want you to imagine organizing this massive grassroots political movement. You're out there pounding the pavement, rallying support, and against all odds, you actually managed to gather over 300,000 signatures.
Which is an incredible amount of work, honestly.
Right, and you do all of this just to put the ultimate question on a ballot for your fellow citizens to decide. You're standing at the finish line, victory is in sight, and then out of nowhere, a single judge completely tosses the entire thing out over this foundational legal issue you hadn't even considered in your planning.
Yeah, it's really the ultimate systemic roadblock. Because, you assume you're operating within the rules of modern direct democracy, only to realize the foundation of the state itself operates in a completely different set of historical contracts.
Welcome to this deep dive into a major legal and political earthquake happening in Alberta, Canada right now as of mid-May 2026. Our mission today is to unpack the intense collision between a massive citizen petition for Alberta's independence and, well, foundational Indigenous treaty rights.
And we are pulling from a really wide stack of sources today. We've got Canadian and international news reports, detailed court decision summaries, and the immediate political reactions from all sides.
We really do. But before we get into it, we need to state up front that because the source material contains some highly charged political content regarding Canadian federalism, provincial sovereignty, and Indigenous rights, this deep dive is going to remain strictly neutral.
Exactly. We aren't taking a side on Alberta separation or treaty rights today.
Right. We are just impartially reporting the facts and the arguments laid out in our sources without endorsing any specific political viewpoints. Okay, let's unpack this.
So to really understand the sheer scale of this collision, we have to look at the momentum of the grassroots push first. I mean, the numbers involved in this petition are staggering for a provincial initiative.
They really are. The movement is called Stay Free Alberta, and it's led by a guy named Mitch Sylvester. So under Alberta's Citizen Initiative Act, citizens can essentially force a government referendum if they gather signatures from 10% of the voters who cast a ballot in the previous election.
Right, and that legal threshold was exactly 177,732 signatures, and they had 120 days to hit that mark.
Exactly. And Stay Free Alberta, they delivered a petition to Elections Alberta with 301,620 signatures. I mean, they completely shattered the requirement.
It wasn't even close.
No, not at all. And the question they wanted placed on the ballot was totally unambiguous. Quote, "Do you agree that the province of Alberta should cease to be a part of Canada to become an independent state?"
Which is just the raw machinery of the Citizen Initiative Act at work. The organizers followed the statutory rules for signature gathering to the letter, anticipating that hitting the number automatically triggered the next democratic phase.
All right.
But that machinery just ground to a total halt when several First Nations intervened with the lawsuit.
Yeah, this was the roadblock. So the Athabasca Chippewayan First Nation, along with the Blackfoot Confederacy, which represents the Siksika, Kainai, and Piikani First Nations, they sued to stop the petition.
And their core argument was that Alberta's separation from Canada would fundamentally infringe on Treaties 7 and 8.
The best analogy I can think of for this legal roadblock is corporate. It's like a group of shareholders successfully gathering enough votes to completely rewrite a company's bylaws, right?
Yeah.
Only to realize the original founders hold this special class of shares that require a completely separate, legally binding consultation process before any structural changes can even be proposed.
What's fascinating here is how accurately that analogy actually maps onto Section 35 of the Canadian Constitution. That's the section that recognizes and affirms Indigenous treaty rights.
Yeah.
Because Treaties 7 and 8, they are living foundational contracts between Indigenous peoples and the Crown. You can't just sever that relationship or attempt to substitute a new independent state of Alberta in place of the Canadian Crown without massive constitutional implications.
It's not just a simple swap.
Exactly. The statutory right to hold a referendum, no matter how many signatures validate it, it just doesn't possess the legal authority to overwrite or bypass those federal and Indigenous agreements.
And this inherent tension is what brought everyone into the courtroom of Justice Shana Leonard of the Court of King's Bench. She delivered this 37-page ruling that completely quashed the chief electoral officer's decision to issue the petition.
Yeah, and her reasoning hinged entirely on what's called the duty to consult, applying what the sources refer to as the Haida test.
Right, the Haida test. We know that's the framework used to determine when the government must consult Indigenous peoples, and it requires 3 elements, right? Crown knowledge of a treaty right, contemplated Crown conduct, and the potential for adverse effects.
Yeah, and the application of those three elements to a citizen petition is where the legal mechanics get really, really intricate. Because the first element is undisputed. I mean, the Crown obviously knows about Treaty 7 and 8.
Sure.
But the second element, the contemplated Crown conduct, that was triggered when the provincial government, via the Chief Electoral Officer, officially approved and issued the petition to gather signatures in the first place.
Oh, so by facilitating the process, the Crown was actually taking an action.
Exactly.
And then the third element, adverse effects, that's where Justice Leonard was incredibly blunt. She wrote, and this is a quote, "As a matter of logic and common sense, there can be no doubt that Alberta's secession from Canada will have an impact."
I mean, she has a point there. You cannot dismantle the provincial boundaries within the nation of Canada and pretend it won't affect the foundational agreements governing the land itself.
Yeah, obviously. But Justice Leonard's ruling also exposed this fatal procedural error regarding how the Chief Electoral Officer handled the newly amended Citizen Initiative Act, right?
Oh, the timeline of those transition rules is a complete bureaucratic mess.
Tell me about it. The Separatist group, they had submitted an earlier proposal back in July 2025, and a judge ruled that first proposal unconstitutional, so the electoral officer officially rejected it on December 8th, 2025.
Right.
But then, just 3 days later, on December 11th, the provincial government passes an amended Citizen Initiative Act that explicitly removes the requirement for referendum questions to be constitutional.
Which is a huge change.
Yeah.
So taking advantage of that amendment, the Separatists just submitted a nearly identical question.
Yeah.
And the electoral officer approved it by treating the old, rejected petition as if it were simply transitioning under the rules of the new legislation.
And the judge just completely dismantled that logic. She started that a rejected proposal is dead. It can't be retroactively revived to bypass the start of a new legislative process.
Right, you have to start over.
Okay, wait a minute, though. I need to challenge the timeline of this legal logic here, specifically regarding that duty to consult, because it feels, I don't know, premature. Well, the petition is just gathering signatures to ask a question. It's essentially a poll to gauge democratic appetite. Why does a legal duty to consult have to happen before the vote even takes place, rather than waiting for a hypothetical yes vote and then consulting First Nations on how to implement the result?
Honestly, the lawyers for the province argued exactly that in court. They tried to position the signature gathering as mere political expression, just the beginning of a conversation.
Right.
But the judge rejected that defense because of the specific mechanics written into the amended Citizen Initiative Act.
Okay, so how does the act change the nature of the question then?
Well, the amended legislation put in motion a series of required mandatory steps. It's not just an opinion poll anymore. Once the Chief Electoral Officer approved that petition, if the signature threshold was met, holding the referendum became legally mandatory.
Oh, wow.
Yeah, the government's own law essentially locked them onto a track with absolutely no exit ramps.
So because the legislation mandated the subsequent steps, approving the petition in the first place became the irreversible trigger.
Precisely. You cannot initiate a mandatory legal cascade that threatens treaty rights and then promise to discuss the impacts after the fact. The court ruled it unlawful to ignore First Nations impacts at the starting line of a binding statutory process.
I mean, taking a petition signed by over 300,000 citizens and nullifying it via a strict judicial reading of consultation duties that is guaranteed to ignite a firestorm. And here's where it gets really interesting.
Yeah.
The sheer force of the political backlash in the capital.
Oh, it was explosive. Alberta Premier Danielle Smith reacted with immediate hostility to the ruling. She labeled the decision anti-democratic and stated her government believes it is incorrect in law.
Right, she's drawing a hard line between physical impacts and democratic processes. She argued that the duty to consult is traditionally reserved for physical infrastructure, pipelines, resource extraction, tangible projects that physically alter the land.
Yeah, and applying it to citizen petitions and the democratic expression of voters is, at least in her view, a vast overreach. She has already promised to appeal the decision.
And Jeffrey Rath, the lawyer representing Stay Free Alberta, he is really amplifying that argument. He claims the ruling contains numerous errors in law.
Right. His reading is that consultation is only triggered by actual constitutional amendments, not by the preliminary act of gathering signatures to see if the public even wants an amendment in the first place.
He went so far as to say, quote, "From our perspective, no rules were broken," which really traps Premier Smith in an incredibly volatile position. The sources literally describe her situation as a horrible political pickle.
It really is a vice, and the pressure dynamics creating it are intense, because on one side, Rath notes that a supermajority of Premier Smith's own United Conservative Party base actively supports this independence vote.
Right, these are the organizers who pounded the pavement and delivered the signatures.
Exactly. They operated under the rules provided by the province, and they expect the Premier to deliver the referendum, regardless of the court's intervention.
Roth even suggested this will become an existential question for her premiership if she doesn't bypass the petition process and place the question on the ballot herself. Because as premier, she holds the executive power to initiate a referendum directly, completely bypassing that Citizen Initiative Act entirely.
But doing so would trigger the other side of the vice. Official opposition leader Naheed Nenshi framed this court ruling not as a defeat for Smith, but actually as a great escape.
A great escape.
Yeah, because the separatist movement is highly polarizing within Alberta. Nenshi is warning that if Smith bows to her base and unilaterally calls the referendum, she will be consciously defying a direct court ruling regarding Indigenous rights.
And the Indigenous leaders are leaving zero room for interpretation on that front. The sources highlight some fiercely definitive quotes.
Oh, absolutely.
Chief Alan Adam of the Athabasca Chippewayan First Nation stated, "This decision should close the chapter on the suggestion of an independence referendum. The court has spoken, and so have the First Nations."
And then Chief Clifford Poussette of the Goodstoney First Nation, he escalated that sentiment into a direct warning to the provincial government. He said, "Premier Smith is officially on notice. There are no legal or political loopholes. We will not allow our rights to be ignored or erased."
Wow.
Yeah, if the executive branch attempts to sidestep the judiciary on this, it will be categorized as a direct assault on Indigenous sovereignty.
So Premier Smith has to choose between alienating a highly mobilized supermajority faction of her own party or initiating a constitutional crisis by openly defying a court injunction protecting historical treaties.
It's quite the choice.
Let's pull the lens back from the provincial capital for a second and look at how the rest of the country is responding to this localized earthquake.
Right, well, if we connect this to the bigger picture, the federal government's posture is highly strategic here. Prime Minister Mark Carney issued a very firm statement asserting that the best place for Alberta is in Canada.
And Carney invoked the Clarity Act, which gives Ottawa the ultimate veto power over the entire endeavor. Under the Clarity Act, a province can't simply declare independence based on a provincial vote.
No, the federal parliament reserves the right to judge two critical factors. First, whether the referendum question itself is completely clear and unambiguous, and second, whether the result represents a clear majority, which is the threshold the act deliberately leaves totally undefined.
Right. The Clarity Act is the ultimate federal backstop. Carney is basically signaling that even if state-free Alberta wins an appeal, and even if they somehow secure a majority in a provincial referendum, the federal government can simply look at the margins or the wording and refuse to negotiate secession.
Exactly. But the most surreal aspect of this federal-provincial standoff is the economic reality playing out behind the scenes.
Oh, right. While the headlines are dominated by secession and constitutional warfare, Prime Minister Carney and Premier Smith are currently negotiating a colossal memorandum of understanding.
Yeah, the administrative arms of both governments are deeply entrenched in finalizing an MOU for a new crude oil pipeline to the West Coast.
It's massive, and this multi-billion-dollar infrastructure deal is intricately tied to a broader carbon pricing agreement, looking at an industrial carbon price of $130 per ton by 2040.
Right, and this is all bundled into what they call the Pathways Project, which is a massive carbon capture initiative in the oil sands. Carney made the linkage totally explicit. He stated, "No pathways, no pipelines."
So you have the political wings of both governments engaged in this bitter fight over the structural existence of the country, while their economic ministries are simultaneously binding their economies together for the next several decades.
It really highlights the dual realities of Canadian federalism. The rhetoric of separation often runs parallel to these deeply intertwined economic mechanics that make actual separation nearly impossible to execute smoothly.
It really does. But to fully understand the public sentiment driving that rhetoric, we have to acknowledge that Stay Free Alberta does not have a monopoly on grassroots organization. The sources detail a massive counter-movement as well.
Oh, definitely.
A petition titled Forever Canadian, advocating for Alberta to remain in the Federation, actually gathered over 400,000 verified signatures last year.
That data point is so vital for context. The separatist movement is highly vocal, sure, and they managed to leverage the Citizen Initiative Act effectively. but there is an actively organized, numerically larger bloc advocating for the exact opposite outcome within the exact same province.
And the legitimacy of the separatist mandate is also taking a hit internally right now. The sources reveal that the Stay Free Alberta petition was recently compromised by a massive data leak scandal.
Right, involving a database known as the Centurion Project.
Exactly. There was unauthorized access to voter lists, which is currently under active investigation by elections officials and law enforcement.
And that really strips away the pure will of the people narrative they were going for. I mean, if the data underlying the signature gathering is tainted by unauthorized access or privacy violations, it hands both the courts and the political opposition another massive tool to invalidate the movement's credibility.
So what does this all mean for you, trying to make sense of this? I mean, this is far more than just a regional political dispute. It's really a masterclass in modern democratic friction.
It really is.
We are watching the unstoppable force of direct democracy. Hundreds of thousands of citizens utilizing a legal statutory tool to demand a vote slam headfirst into the immovable object of constitutional law and historical Indigenous treaties.
It challenges that simplified definition of democracy as mere majority rules. This whole scenario highlights the structural guardrails designed to protect minority and foundational rights from being unilaterally swept away by popular majoritarian movements.
And those guardrails are doing exactly what they were engineered to do, but the political stress on the system is immense.
I want to leave you with a final puzzle to mull over on your own, actually. A potential outcome that builds directly on the legal mechanics we've unpacked today. We discussed that analogy of realizing you have to cross sovereign land before you can even propose a change to the map.
Right, the requirement to consult before initiating the legislative cascade.
Exactly. So if the Alberta government pushes forward with their appeal, taking this fight all the way to the Supreme Court of Canada, and they ultimately lose, and they end up losing the case, could this separatist petition inadvertently end up setting a massive continent-wide legal precedent?
That's a huge question.
Right. If the highest court rules that even the preliminary act of asking citizens about altering the structure of the state requires proactive Indigenous consultation, could this failed separatist effort drastically expand the legal interpretation and power of Indigenous treaty rights across all of North America?
It's wild to think about. The organizers set out to build a new nation, but they might end up permanently rewriting the constitutional rules for everyone else.